Okay, so I couldn't have done this without the support and help from my wonderful staff. So I wanted you all to be able to see them because, again, if we were doing this in person, I would introduce them. So I wanted you guys to see who all works at our office just so that you can put some faces with some names and be able to recognize people when you call in. It's always nice to be able to know when you're calling, who you're talking to. So we have Sandy. Sandy's in the blue on the far left in the back. Amy's in the center wearing the white, and then Tammy's on the right. She's wearing blue there as well. So Sandy has actually she worked for Tucker for over 50 years, Tucker Maxwell, and she works in our office 3 days a week. She's our receptionist, and she provides support for the estate administration and the estate planning department. And she also is one of the notaries in our office. And we love Sandy. Sandy has so much life experience that, just general good advice that she's able to give me as well. So we appreciate Sandy. We have Tammy. She began working for Tucker in 1985, and she was born and raised in Waynesboro. She handles our estate administration in our office, and she's one of the notaries. And we're glad that Tammy was able to join us starting July 1st. Then we have Amy, and Amy actually began working at Maxwell Sype in 2017. She used to work for an insurance company prior to that. She's born and raised in Waynesboro, and right now she's handling our marketing and client relations. So you guys would have received your emails from Amy regarding the seminar. She does a lot of our social media posts that we're doing. And we also wanted to send letters to clients to let them know what services we had and how to get a hold of us. So she was in charge of all of that. So we appreciate all of Amy's hard work getting ready for this. And as you all know, as we've been navigating this virtual world that we've been living in, there are so many things that you don't think that you need to learn how to do. So Amy's tested out some things for me as we've been working on the seminar, so I appreciate her help. So I just wanted to let you guys know who our staff was, and I also wanted to make sure that everybody knew that all of this, we couldn't do it without any of them. So I really appreciate all of their hard work. Okay, so I wanted just to have my bio on here. I'm not going to go over it real extensively. Just wanted everybody to be able to have the material. Happy to answer any questions anybody has about that. But I wanted you guys to be able to see it actually in writing. And the one thing I did want to mention is I co-authored a book. It's the What You Really Need to Know About the Second Half of Life. And I have that pictured on the left side. And we do have copies of those. So if you haven't received a complimentary copy, we're happy to mail that to you. You're welcome to read through it. The chapters that I wrote deal with business succession planning. I talk a lot about my parents. They had a farm, so I talk about that transition, and then just general business succession planning. But anything in that book, we actually do here at the office. We do long-term care planning and asset protection planning and nursing home planning. So any of the material that you find there, I'm happy to answer any questions that you might have about that. Okay, and then I also wanted you guys to know our mission statement. So our mission statement is really important to us. When we were sitting down trying to figure out what direction we wanted the office to go in, we wanted to create a mission statement and kind of a tagline so people knew what we were about and what we were hoping to offer the clients. So we want to provide mindful legal direction for you and your future generations. And we want to do that, and we're using 4 principles to do that, and that's just collaborating with your accountant and financial advisor to create the best team for you. The way I look at it is I know the legal stuff, but you have so many trusted advisors in your life who have offered great advice and are so important to you when you're making these decisions regarding your legal documents and plan. And so we wanted to make sure that we put an emphasis on that collaboration, and we really welcome accounts and financial advisors to be part of that team, and we're happy to provide that legal support. We also want to be able to advocate for you and your family in times of crisis. So we have families who are dealing with parents or siblings who are in a nursing home and making sure that they have the support there that they need, whether it be getting into a facility or qualifying. We want to make sure that we're able to do that. So that's how we're able to help in times of crisis. And so you're always welcome to call. We'd be happy to troubleshoot or to guide you in that direction. We also want to reinforce your estate plan with asset protection strategies. So whether it be, you have a business and you want to make sure that you have the proper protection there, or whether it is that you're looking at nursing home and you want to know what is available, what can I protect for my spouse or for my kids, we're happy to offer some insight there and to help shore up your estate plan with those asset protection strategies. And that's some of what I'm going to talk about with your powers of attorneys. It starts with those basic documents, and knowing those asset protection strategies are important even in those documents. So I'm going to go over that as we go through this session. And then we want to ensure efficient administration upon your death. And more I'm learning, as families go through the death of a loved one, they have so many emotional things they're going through, and they really need guidance legally as to what's the most efficient way to do this. Are there ways that we can do this to minimize tax? Are there ways that we can do to minimize legal fees? And so we want to offer that protection and guidance and assurance that, we can do that with the most efficient process that we do. And I really have to give credit to Tammy and Sandy here. They have helped create a great system that we're able to efficiently serve our clients in that area. So we're ready here and able to help whenever you need. So that's our mission statement. So I just wanted to share that with you folks as we go through this. So what services do we offer? So we do estate planning, asset protection planning, special needs planning, long-term care planning. That would be, if you want to protect assets and you're going into a nursing home, how legally can you do that? Medicaid planning. So if you're actually going into a nursing home and applying for benefits, there are certain strategies that we can guide you in that would allow you to either be able to qualify more quickly or to be able to preserve assets for your spouse. We also do business creation and management, as well as business succession planning. We do estate and trust administration, and then we do some tax planning as well. And that we really collaborate with the accountant to do that. But we always like a good tax discussion. So a lot of times when I'm meeting with clients, we go over what goals they have. And so these are a lot of times what a client will mention their goals are. And what I ask them to do is kind of rank them. What's most important to them, most important to least important. And the reason why I brought this up today is that these are pretty across the board. When I meet with clients, these are the pretty standard goals that most everybody has. And so what I want to talk about is these goals. Although, we're looking at the end goal, we have to start with foundational documents. So even though we have these goals that are really, really important, we have to start at the beginning. And the way we do that is with the estate planning. So I was trying to think of a way to illustrate this best. So through this pandemic, I have noticed that people are returning to a lot of lost arts. And one of the things that my family has been doing is that my dad always does a garden. Every year he's always done a garden. And what happens is my dad is in charge of the garden. And then usually my mom or we will take care of the produce coming out. So my dad really went above and beyond this year and planted a lot of zucchini. And I don't know about you guys, but I love zucchini, but there's only so much like raw zucchini, or even, sometimes we put it in the oven with some olive oil. There's only so much of that you can eat. So my mom and I have really been falling back on the lost art of baking, and particularly zucchini bread. So I wanted to relate it to that. So for example, when I was in high school, every summer my parents would give us a job. And one summer my job was to make sure to plan all the family meals. And those of you who know me know that I have 3 sisters. I'm one of 4 girls, and I'm third in the line. And one summer my job was to make the meals, which I was thrilled to do. Being the third, a lot of times my older sisters got to do that. So when I was in charge of it that summer, I was really excited about that. The issue was that I tend to like to make healthy meals, which is, everybody likes a healthy meal unless you're my dad and your opinion is that red meat should be a part of every meal. That's really important. You need to make sure you have your red meat. So I decided I was going to do vegetarian that summer. And I remember this particularly because I was playing field hockey at the time, and I would have to go to field hockey camp, and we were having practices twice a day. And so what I would do is I'd go in the morning, and then I'd come home and bake zucchini bread, and then I would go back for the evening session. Or sometimes we would, if the practice was just one time a day, sometimes I would do it in the morning, afternoon. The point of it is I made zucchini one summer, and I made 30 loaves of zucchini bread that summer. And I got it down to an art where I could do it really quickly, really efficiently, and could make multiple loaves in a day. And so it became this fun project that my sisters and I did. I was in charge. We were making healthy things. Zucchini bread counted. And so when I was thinking about estate planning, I was like, well, this is really a lost art that we need to embrace. I'm going to pause here. I think I'm trying to mute everybody as I'm talking, but I think somebody has their sound on, and perhaps you can mute it. That way we don't get the feedback. So just double check and make sure that you're muted. I appreciate it. Okay. So the lost art of the zucchini bread. So in the pandemic, I realized that we really need to go back to our basic estate planning documents and make sure they're where we need to be. So how does that relate to the pandemic? So the toilet paper crisis that we all had to deal with came into play because, toilet paper probably really isn't a necessity. However, if you don't have it, it becomes a little bit messy. So same way with estate planning documents. If you have good estate planning documents, then you don't have the legal mess that you would have if you didn't have them. Okay, so I'm going to talk a little bit about that. So step one is that we want to make sure that we're protecting you and your family with great foundational documents. How do we do that? So let's go through that. So we have 5 documents. We call them the Hot 5. These are the power of attorney documents and the last will and testament. Every person on this call, every person I meet with, every person that I see in the store, everybody I come in contact with, no matter how old or how young you are, should have these documents. So the power of attorney documents, our office has 4 of them, and I'm going to talk you through those 4. So the first is the financial power of attorney, then we have the healthcare power of attorney, then we have the living will, then we have the mental health power of attorney. So the financial power of attorney is the one we're going to start with. But please notice that when I'm talking about this, I am going to compare them to documents that I have either seen in our office, that I have reviewed, or that I've seen other attorneys do. And then I'm going to try to show you some language that we would recommend. And please know that all of this is couched in the sense that when you go back to what we want to make sure that we're really focusing on is having those good foundational documents and thinking through the second half of life. So we want to, again, at any age, you want to have these documents, but really there are certain powers you want to make sure your agent has when you're planning for the second half of life. So let me go through each document here by itself. And again, as you guys have questions, please feel free to enter it in the chat box. I'd be happy to answer questions as we go along and then at the end if we need to. So what's the most important estate planning document you can have? So a lot of times when I ask clients this, they say the will. Of course, everybody needs a will. And that's true. But I think the more important document is the power of attorney. And why is that important? It's important because a will is you've already died. You've passed away and your assets are being distributed. So frankly, you don't really care what's happening. There's no impact to you. But for a power of attorney, it's very impactful while you're living. So this would be, the example that I use quite often, and I know that some of the financial advisors that I work with use it, would be if you got hit by a bus. So if you get hit by a bus and you don't die, but you're incapacitated, who can make those decisions for you? And so that's really a power of attorney. And it's a written legal document where one person, we call that the principal, authorizes another, who's the agent, to act on his or her behalf. And I'm going to try to give some examples. And my family, they're the best examples that I can give. So I apologize prior to this if any family members are on here because I am going to reference them. So please forgive me going forward. But I'm going to use my family as an example. So we have these 4 powers of attorneys. And believe it or not, I'm an attorney and I've been practicing since 2010. And my parents just started getting these documents in place. I feel like I needed to give it to them for a Christmas gift in order for them to get it done, but we did finally get these documents in place for them. So one of the questions that we have is a general power of attorney the same as a financial power of attorney. So let's talk about that. So when we're dealing with powers of attorneys, the MVP of the power of attorney is a financial power of attorney. Everybody needs this document. And the reason why this goes really well with the question that was asked is whether a general power of attorney is the same as a financial. It depends on the document. So sometimes I see clients come in and they have a general power of attorney and it has the financial in there and it has the healthcare power of attorney and it has a living will. It's all combined in one document and that's just their general power of attorney. And that works fine. That's an okay way to do it. It's not my preference. My preference is that each document or each power of attorney be a separate document. And I'm going to explain why I prefer that. Okay. So if we're talking about powers of attorneys, the MVP is the financial power of attorney. And the question here is it a durable or is it a springing? So Ken, I know in your question in the chat box is general power of attorney. Hopefully I answered that. The financial power of attorney is specific to finances. So when we draft them in our office, we have a separate financial power of attorney, meaning that there are no powers related to your health in that document. And the reason that we do that is so that if my parents name me as their power of attorney, and let's just say I'm their favorite and they want to name me as their power of attorney, and I'm going to be handling their bank stuff, and I'm giving a copy of that power of attorney to the bank, I'm probably not going to want, neither me nor my parents are going to want the bank to see my healthcare decisions. Vice versa, if you have a healthcare power of attorney and a financial power of attorney together, when you give it to the doctor, then, it has all of the financial stuff in there. And so usually it's a good idea to separate those documents. So we have a durable or a springing power of attorney. Our office prefers durable. And the reason is because a springing power of attorney under Pennsylvania law requires 2 physicians to say you're incapacitated. And I'm just looking at it from purely an ease of administration, for example. So if it requires 2 people to agree, 2 physicians, in our experience, that usually takes about 2 weeks to get 2 physicians to be in agreement. And so we want the power of attorney, if we're trusting this person and wanting to empower them, we want to give them the power immediately to be able to act. Now in Pennsylvania, it's not effective until the principal. So in this case, let's pick on my dad. Let's say he does it and he's naming me. So I would be the agent. My dad is the principal. It's not effective until my dad signs it and I sign the acknowledgement page. So sometimes we have parents who are naming their kids who say, well, you know what, maybe we're not going to have our children sign the acknowledgement page yet because we don't want them to be able to have the power until they actually need the power. And then if and when the situation would come up, in our example where I'm the power of attorney, if there would be a situation where I need to act, then I would take the acknowledgement page and sign it in front of a notary at that time. Okay. This is an example. I took a picture of a springing power of attorney that someone brought into our office. And you're going to see the reason why it's springing is because it says it shall become effective. And it's when this individual is disabled or incapacitated. Okay. So it's springing at a certain event, meaning it doesn't come into play. It doesn't activate until I'm disabled or incapacitated. And again, in Pennsylvania, unless the document says different, it requires 2 physicians. So we prefer a durable power of attorney. So what I would encourage everybody to do is to go, if they have a document already, is to go pick that document up and to look through it and to see, does it have any language like I'm showing you here? Does it say that it's only effective if you're incapacitated? Does it say in there that you have to be disabled? Does it say at the top of the document that it's a springing power of attorney? So start at the subject. Does it say at the top it's a spring or a durable? And then even if it says it's a durable, is there language in there throughout the document that talks about you have to be incapacitated or disabled? If so, then it's actually a springing power of attorney. And again, we always recommend in our office to have a durable power of attorney. And I'm just going to make sure everybody has it on mute so we don't get the feedback. I have a little bit of feedback, so just double check, make sure you have your volume along the bottom. There's a microphone, make sure that's muted. Okay, so one of the questions is, how often should a power of attorney be updated as life changes occur or review every year? A lot of that depends on what the law does. So the most recent law change as it relates to financial power of attorneys was 2015. 2015, and I'm going to skip ahead and come back, okay? So let me go here because I actually have this in here. So it was Act 95. It was signed into law in July of 2014, and it became effective January 1st, 2015. So that was the last big law change that we saw specific to financial power of attorneys, okay? And the reason why this changed is because there was a court case where husband and wife were married and they had executed a power of attorney, and wife had named husband. And then she was in an accident and was in a coma. And while she was in a coma, husband made some elections. She was a retired teacher. So husband had made some elections on her retirement, pensions, and all of that. She came out of the coma. They decided they didn't like each other anymore. And they got, were getting divorced. And then wife was upset that husband had used the power of attorney to make some elections. And so banks stopped accepting power of attorneys. You had to prove that it met certain requirements in order for a bank to accept any action done by a power of attorney. So the legal community responded to that because, again, the whole point of this is so that you don't have to go before a judge, get a guardianship, have all of that cost and expense. So if you're going to have a power of attorney, you want it to be effective when you need it. And so the legal community responded to that. And so what happened was in 2015, now they say if you have the required notice, and the notice is going to be the first page of the power of attorney, it's in all capital letters. So if you have that notice, it changed in 2015 to have different language in there. So if you signed it post the new law in 2015 and you signed it in the presence of two witnesses and a notary, then the presumption is that that power of attorney is effective and that is what you wanted and who you wanted to appoint. If it was done previously, it's not that that power of attorney is not acceptable. It's still effective. It still works. It's just that sometimes the banks know that the 2015 law, allows that presumption. So they may just have an affidavit or something additional that you have to sign in order for the power of attorney to be effective. So we always encourage clients that if they have the capacity to revisit it when there's a law change or when their life changes. So if, their kids become of age and they want to appoint their children, or if, something happens to their spouse and they want to update it, that would be another good time to change it. What we do in our office is we recommend an annual review. We don't charge for the annual review, but we like the client to come in because then we say, what's changed in your life? And then we can say, this is what's changed in the law. And we can figure out, do they need to update? So we don't charge for the update appointment. What we charge for would be if there would be any changes. And most of the time, there aren't going to be any changes unless there's like a big law change or unless your life circumstances have changed. But at least if we're meeting yearly, you know that and we know that if something has changed. As far as the healthcare, and I know we haven't gotten to the healthcare power of attorneys, but I want to go ahead and answer this. How often should those be updated also depends on the law changes and your life changes. So the financial power of attorney changed in 2015, but the healthcare power of attorney had a change just this past year. And the change dealt with organ donation. So I'm sure many of you have on your driver's license about organ donation and that you want to be an organ donor. And in Pennsylvania, the default, if you have either designated on your license or if you have it in your document that you're an organ donor, it's major organs, heart, for example, but it doesn't include tissue. And the reason why is because if the default included tissue, then there is a lot of times there is a contradiction between what the living will says, because it might say no end of life decisions, but if you're an organ donor and you want tissues to be able to be harvested in addition, you might have to be put on life-sustaining equipment in order for them to be able to harvest those organs or that tissues appropriately. I know that the cornea of the eye is one that they need to make sure that you have been properly preserved if you would need to harvest that. So what we have to ask our clients is, do you want tissue to be included in that? And if so, then we put a clause in there that you understand that that means that you might have to be put on life prolonging procedures or machines in order for that harvesting to occur. And so we always want to talk to our clients about that update. So again, that was a law change, but your life might change as well if you get a diagnosis, and that would be another time that you would update it. So I'm going to go back a little bit. If everybody just hangs with me, let's go back. So the types of power of attorney, this I'm cluing in on the financial. So the financial power of attorney authorizes the agents to make financial decisions. So the powers that we typically see: open and closing bank accounts, selling real estate, defending in litigation, making any gifts, creating a trust. Okay. So if you think about it, the Pennsylvania statute has a set of powers that it says, if you just mention these generically, then your agent has the power. But then they have what they call these hot powers. And the hot powers are where specific language is needed in the document, and it's specific language the statute actually says it has to use this special language in order for your agent to have that power. And those hot powers that we call them are gifting powers, the ability to create an irrevocable trust, access to digital assets, and the ability to update beneficiary designations. So let me give you an example of when this is important. I'm going to pick on my parents again. I'm going to pick on my dad in this situation. So let's say mom and dad, let's say they're in their mid 80s and dad is, having some issues and he needs to go into a facility. And my mom is able to live in the community and she's still doing well. She doesn't need any care. In that case, they might meet with me and talk about, let's see if we can preserve some assets for my mom. Because if my dad goes into a nursing home, whether my mom's name is on the asset titled in both names or whether it's just in my dad's name, it's going to be available for my dad's care. And my mom can only keep about $126,000. That changes every year. They usually increase it every year just a little bit, but my mom would only be allowed to keep $126,000. And so what I would do with tell my mom, I would tell her, well, maybe we want to take dad's name off some of these accounts and just put them in your name so that we can allow my dad to either privately pay with specific assets or maybe get some help with Medicaid so that my mom doesn't have to use all of her assets. That's not to say she wouldn't use some, but that way she's not financially compromised because she could live for another 10 years. And if she only has 126,000, that won't last long. So in that case, what we might do is we might take my dad's name off the house. We might take his name off some bank accounts. And in Pennsylvania, even between spouses, if my dad is unable to make that transfer and we're relying on the power of attorney to do so, the language has to specifically say unlimited gifts. And the reason why is because if it just says making gifts, then my parents, even between each other, could only make a transfer of $15,000, nothing more than that. And their house and their bank accounts is probably worth more than that. And so even if we wanted to take my dad's name off and just put it all in my mom's name, if the power of attorney doesn't specifically say unlimited gifts, then my mom could not do that. Okay. The other thing is if my mom wanted to create a trust to protect assets, if the power of attorney doesn't specifically say that she can create an irrevocable trust, then my mom is not able to do that, which means that I have a niece who has special needs. If my mom wanted to create a trust for Audrey that would allow her to qualify for benefits and put assets in there that her and my dad wanted, she would not be able to do that using my dad's power of attorney unless the document specifically said she could make an irrevocable trust. Same thing with digital assets. This was a new law that came out. Actually, I want to say it was in the last 2 weeks, the governor signed it and says that if you don't specifically say digital assets, then your power of attorney is not allowed to access those digital assets. And then beneficiary designations. If your beneficiaries, if you would like to update them, and again, I give the example of Audrey with my niece with special needs. If my parents wanted to update their designation, or if I, as their agent, wanted to update their designation because they couldn't do it using the power of attorney, their power of attorney has to specifically allow me to be able to update those beneficiary designations. Now, in Pennsylvania, just know that I would not be able to deviate from my parents' estate plan. So it's not like I could say I'm going to update myself and put myself as the power or as the beneficiary of all of this. So just granting your agent the power doesn't mean that they have the ability to change it to themselves as the sole beneficiary. They have to follow your estate plan. And I have a question on the chat box that's just saying, is mom's IRA protected? This goes a little bit more than the power of attorney, so I'll just briefly answer it because it's an important question. And the answer is that my mom's IRA would be protected. So if my dad's in a facility, his retirement would be available for his care, but my mom's retirement would not be available for his care. But that's the only asset. Retirement is the only asset that's like that. Everything else would be available for my dad's care. The other question is, could I please define digital assets? Yes, the statute specifically defines digital assets as any online accounts that you might have. It would be any online payments that you're making. So if you wanted to be able to allow your agent access to online banking for you, it has to have digital assets. If you want them to be able to handle like iTunes or any digital asset like that, it specifically has to mention that. So the statute does outline digital assets and what that includes, but just know that it's pretty much anything related to the computer, whether it be you're accessing the account online, that would be considered a digital asset, or if it's actually a digital asset like your iTunes account or something like that. It applies to both of those things. So this is an example of powers that I see often in a financial power of attorney. And a couple of things I wanted to point out. Number 14 on the list is creating a trust for my benefit. Because it doesn't say the word irrevocable, it means that the agent could not create an irrevocable trust. And the irrevocable trust is what would provide the asset protection. So it doesn't allow a lot of protection. I had a client where dad was in an accident and there were two sons. One son had special needs, and really we were doing an irrevocable trust to be able to transfer assets to the son with special needs. It allowed dad to qualify for Medicaid benefits immediately, but more importantly, son with special needs doesn't have a job that would sustain financially him. So creating that irrevocable trust and transferring those assets in there was really important so that the nursing home couldn't use all of those funds, that son with special needs would still be able to be cared for properly the way mom and dad would want to. So number 14 there, we would actually recommend to change the language to say to create an irrevocable trust, a revocable or irrevocable trust for my benefit. The other thing that you're going to see here is that, again, it doesn't allow beneficiary designations on there. So it talks about under number 8 and 9, engaging in insurance transactions and engaging in retirement plan transactions, but it doesn't specifically allow beneficiary updates. That actually has to be spelled out in the document. Otherwise, you do not have that power. And then in here, there's no gifting power. So it means that, again, even between husband and wife, my parents would not be able to transfer assets back and forth. And that would be problematic. So again, we would recommend having those beefed up, those hot powers actually spelled out in the document. And just so you know, when you're looking at a power of attorney, if you have one in front of you, check when it was executed. Was it pre-2015? If so, you might want to get it updated. Does it talk about it being a springing power of attorney? If so, you might want to update it. Does it have these hot powers in there? If not, you might want to update it. So these are things that if you have a document, I would recommend that you go back and look to see what you have and what you should have in there. This is an example of the language that we use to create trust, that the agent has the power to create, fund, amend, modify, revoke, or terminate a revocable or irrevocable trust. And I guess my thought is that if you're naming somebody you trust as the agent, why not give them the maximum amount of powers that they can have under the statute? Because otherwise they're going to have to petition a judge in order to have the right to make those decisions. So let's put the powers in there to allow them to be able to do what they need to do. This is an example of the gifting language, to make unlimited gifts. And again, the reason why this is really important is because if my mom wanted to protect more assets so that she, didn't have to be financially compromised with only having $126,000 if my dad needed care, this is the language we would need in the document. Okay, so even if you aren't doing asset protection planning right now, you still want to have it in the document so that as you age, you can engage, or your agent can engage in this type of planning if they would need to. This is an example of the beneficiary designation language that we recommend be used. And we recommend it, we spell it out for retirement plans, life insurance policies, and annuities, as well as transfer on death designations and pay on death designations. This is the digital asset stuff. Now I cut it off a little bit because it's a huge paragraph, but just saying that your agent can access, modify, control, archive, transfer, and delete any digital assets. I talked a little bit about this and the changes that we had happen in 2015. So again, just take a look, make sure that your document, if it was executed pre-2015, check and make sure, does it have all of these things that we're talking about? And also know that if you look at it and you're unsure, I always recommend bring a copy. We have free initial consultations here. Bring a copy of the document. I block off an hour and a half and I'm happy to take a look at the documents. I feel pretty strongly about it, as you can tell, since I'm almost 40 minutes in and I'm still just talking about the financial power of attorney. I feel really, really strongly about it. So I always recommend bring the document, whatever you think would be important, bring it with you. I'm happy to actually look at it while we're in the appointment and tell you what works and what doesn't work. Okay, so that covers the financial power of attorney. Let's talk about the healthcare power of attorney. So this document authorizes the agents to make medical decisions, consent to surgery, admitting or discharging from a hospital or nursing home. We want to have the HIPAA release language to be able to review medical records. And then we want to be able to have organ donation, or even if you have a preference for cremation, we actually recommend that that go in the healthcare power of attorney and in the living will, because your agent needs to know that before you actually pass away so that they can make decisions about what to do upon your death. Okay. Now, the healthcare power of attorney and the living will are actually effective at two different times. So a lot of times when I see them, somebody comes in and they have an advanced healthcare directive and it has the healthcare power of attorney and the living will combined in one document. We don't do that in our office. We actually have a separate document. And the reason is because they're legally effective at different times. And so I want the agent to be well informed about when do you use the healthcare power of attorney versus when do you use the living will. So, if we're not in end of life, then we only want to be under the healthcare power of attorney. If we have a terminal diagnosis and you're unable to express your wishes, then we're under the living will. Okay, so we have them as two separate documents. And we put the HIPAA release in there because, again, if I'm going to be making healthcare decisions, then I need to be able to access that medical information for my parents if I'm being listed. So the living will typically is a component of the healthcare directive, and it's express of your wishes dealing with end of life. So it's if you can't express your wishes and you have a terminal diagnosis, it provides what you would want. We have the HIPAA language in there and we have organ donation language in there. And what I wanted to specifically talk about are two things that a lot of people do not have in their document. So the first thing is they do not have a distinction between artificial nutrition and artificial hydration. This is so important. So I am not a medical professional, but what I can tell you is legally, if it says, like this document says, that, all forms of artificial nutrition and hydration, they're saying here that, your agent has that ability to be able to authorize, withhold, or withdraw medical care, surgical procedures, all of that. We actually do it differently. So we have two different paragraphs. We have a paragraph A that says that you're okay receiving pain relieving drugs, even if that means an IV has to be put in. That also means that you're okay if they're going to put in like a saline drip to keep you comfortable so that if the doctor says you're dehydrated, you can be kept comfortable. We want to distinguish between hydration and nutrition. So we're okay with hydration if it's used to relieve pain, but we don't want any life prolonging procedures. So we have everything from CPR to a breathing machine to dialysis to surgery, chemotherapy, radiation, antibiotics, and a feeding tube. The question I get most often when they're reading this list is the antibiotics. And the example I give, and again, this is dealing with just a personal life example. Someone in my family had emphysema pretty bad, and at the end of their life, they were getting pneumonia, and they had to be on antibiotics all the time. They weren't clearing it. And so that would be considered life prolonging. If, however, that individual had an infection that antibiotics could clear, legally, that's not life prolonging. So it's not saying no antibiotics. What it's saying is that if you cannot come off the antibiotics, if you have to stay on the antibiotics in order to continue to treat it, and if you went off of it, you would pass away, then that would be considered life prolonging. So I always like to make that distinction because sometimes people get a little nervous when they see that you are saying you don't want antibiotics. So remember, it's you can't express your wishes, you have a terminal diagnosis, and the doctor is saying that this is life prolonging. And so we typically make that distinction in our document. And this is in the living will. It's not in the healthcare power of attorney because the healthcare power of attorney is only effective if you can't express your wishes. It doesn't have any bearing on a terminal condition, though. So that's why we have them as separate and distinct documents. The other thing that we want to put in our living will deals with dementia or Alzheimer's disease. That's not legally a terminal diagnosis. It doesn't meet the definition of a terminal diagnosis legally. So we need to allow our agent to be able to refuse the insertion of a feeding tube if you progress to the point where you lose the ability to swallow, or if you need that feeding tube. What you're saying is that you want the rest of your living will to be activated at that time. Okay. So again, legally, Alzheimer's and dementia is not a terminal diagnosis. So normally it wouldn't be activated. So we have to have a paragraph in there that says, if you have that diagnosis and you progress to the point where you lose the ability to swallow, you don't want a feeding tube put in, and all other provisions of your living will would then kick in. Okay. So I'm mentioning all of this because if you have a healthcare power of attorney or a living will already, the law change deals with organ donation. So go back and see, what does your document say about organ donation? And then also go back and see, does your document have the language in there about the distinction between nutrition and hydration? Does it have radiation, chemotherapy, all of that in there about life prolonging procedures? And does it have the dementia and Alzheimer's language in there? And if it doesn't, then that is something that you may want to revisit or update. Okay. So again, it's not that your life situation changed. It's more that the law has changed and we have to have that specific language in there. The mental health power of attorney is the last power of attorney document. And I really don't like this document, but I'll tell you why we recommend it. So I don't like it because under Pennsylvania law, it automatically expires every 2 years. It's the only power of attorney that does that. So if you sign it today, in 2 years from today, you still have capacity, you have to re-sign it, okay? So we have to make sure that we are reminding clients. And what we do is we send out a letter every 2 years that says, hey, it's expiring. You might want to come in and re-sign. The reason why you want to have this document is because your healthcare agent under the healthcare power of attorney cannot consent to experimental treatments or drug trials. Okay, that's important with dementia or Alzheimer's specifically, because sometimes it's labeled experimental for federal funding purposes, but you would want your agent to be able to consent to it because it's making great headway. And so again, if our thought is that we trust these individuals that we're naming and we want to give them the maximum amount of power that we can under the law so they don't have to petition a judge, then we want them to be able to have this power. Now, what the document says is that your agent has to consult with your treating physician and determine what is in your best interest before they can make any decisions. So know that you are going to have that protection of, it's not your agent's just going to be consenting to whatever, okay? So I wanted to make sure to cover the mental health power of attorney. Why do you need one? In Pennsylvania, more and more, and under the law, and that's why it's happening more and more, sometimes the physician will not even share information with a spouse. We actually had a situation where we had a spouse that was dealing with dementia, and the other spouse took them to the doctor's appointments, and the physician would not even allow the spouse in the room with the doctor to discuss it, nor would they share things like height and weight, because there was not a power of attorney and there was not a HIPAA release signed in the file. So this is really important. So even if you think, oh, my spouse will just take care of it, you really need to have the document in place because legally they actually don't have the power. In Pennsylvania, there used to be an assumption that if you were married, that you liked that person and that's who you would want to be the power of attorney. But now there is not that assumption anymore. So you actually have to appoint your spouse, and then we recommend at least one, if not two, successor agents. You want to do this because if you don't, your children, your spouse has to obtain a guardianship legally in order to make these decisions. And on average, it takes about 3 months for guardianship. And that was pre the COVID-19 things and the shutdown with the court system. So I can't imagine what that timeline is like now, but it was 3 months. And if we're dealing with the cost of a nursing home, for example, and we want somebody to be able to admit or be able to do planning, for example, for nursing home care, the average cost of nursing home is about $10,732 a month. If you multiply that by the 3 months that it takes to get a guardianship, that's $32,000 that you're unable to properly plan for. Now, again, it could be that you were going to pay that anyway. It's not a big deal, but if you're able to qualify for a benefit, but your agent is not able to actually do that work for you, that's what we're talking about, the $32,000. it would be a loss of that money because normally a benefit, Medicaid, or some other government program would be covering it. Okay. So that's why you would need it. Now, the last foundational document is the will. And again, I spent quite a long time, 45 minutes, talking about just the power of attorney documents. So I feel like the last will and testament is going to be a little bit anticlimactic because honestly, the law has not changed a lot with wills. What I'm noticing is that a lot of people do not understand what is distributed per the will. So if I have a life insurance policy, if I have a retirement plan, if I have an account with a transfer on death designation or a pay on death designation, that's not going according to my will. That's going to those beneficiaries who I've designated. If I have a joint account, meaning husband and wife is jointly on it, then that doesn't go through the will. So it's not that the law has changed, it's just that we have really good financial advisors and we have so much information out there that people now know that you can designate beneficiaries on there and it won't pass by your will, it won't go through the probate process. Okay. So the will is really just for any other assets that you can't name a beneficiary on that's not a joint owner. Where do those assets go? Okay. And what I've noticed is that this is also important when you're saying who should pay the tax on these assets. Does it come out of the residue or does each person have to pay their share? The will is really important there. It's also really important if you have minor children because you want to make sure you're naming a guardian or a custodian, and it can be the same person or different people. So the custodian is the person who handles the finances. The guardian is the person who physically would have custody of the kids. And so that happens in your will, okay? The other thing to know is that if you're married, a lot of times I get this question. So if, well, let's just talk about my parents. If something happens and my dad kicks the bucket first, my mom can change her will. So when you have husband and wife and everything is jointly owned, I always like to make sure that the spouses know it's really the last man standing. That's the will that's really going to govern it. So you want to make sure if you are a blended family or if you have a second marriage, that you're addressing that because you may want to make sure that it doesn't all go to your spouse, that it's going maybe to your children or to your lineal issue in different percentages because your spouse can always change that. And again, we never like to think that way, but we have to kind of think legally. We like to think the worst case scenario and plan for that. So we want to make sure that we are protecting both of you so that if that spouse would get remarried or if it is a second marriage, that your kids are being provided for the way you would want to. Okay. In Pennsylvania, that's where you would also name your executor or your personal representative. That's who goes up to the courthouse and gets sworn in and gets appointed and is the person who actually distributes the assets according to your will. Okay, so that's your last will and testament. The other thing I like to point out, because I know that there are a couple of people on the call who do have minor children. So this is important. Pennsylvania has a standby guardianship statute. And what that means is that I have a younger sister, Jessie, who has two underage children. So if she and her husband are going away for the weekend and they want me to take care of their kids for that weekend, I might say, hey, why don't you fill out this form, which I can email to anybody who wants it. It's just the statute has a form embedded in it. And it's who you would appoint to be the guardian while you're away for that limited period of time. But it's saying that it's just for that period of time. So just for this weekend, if something would happen and I have to take one of them to the emergency room, I can do that and I can sign all the documentation I need. The will is permanently. So if something would happen permanently to my sister and her husband who has custody of the kids. So I advise parents who have underage kids that if you're traveling and the kids are staying with someone other than who would be the guardian if you passed away for the weekend, to have that standby guardianship form completed for every out of town trip that you're taking so that that guardian can be able to get treatment if that underage child would need it. Okay, so I wanted to make sure to do that. So one of the questions I'm getting is what language do you recommend related to paying taxes in the will? So there are two ways you can do it. The one is that in the will, you can say all the taxes come out of the residue. Okay. And what that means is that if you have charitable bequests, like you have 10,000 going to your church and 10,000 going here, let's say my parents say, 10,000 is going to the church, and then we're going to give 10,000 to a close family friend. The question becomes who pays the tax on the 10,000 that's going to the close family friend? Does it come out of their 10,000 Or does it come out of the residue, which if the residue is coming to my sisters and I, that means that that person gets the full 10,000 and what we're left over with pays the tax for everybody. Okay. So we want to make sure the will says, is it being paid out of the residue, or is it each person is responsible for paying their tax? The other reason why this is important is that Tammy and I are working on an estate right now where a tax has to be paid. And there are some beneficiary designations, and it all went out to those beneficiaries. And the question becomes, who pays the tax? They've already gotten their money. So are we going to ask them for the tax, or is the will saying that anything that passes through the will is actually what's paying the tax, even on assets that have a beneficiary designation? So that's what I'm talking about. We call that our tax apportionment clause. So I always like to ask the client, especially if they have specific requests or if they have beneficiary designations, who's actually going to be paying this tax? Because it's the person who files the inheritance tax return that has the worry of figuring out how is it going to be paid. And so we like to address that so that that executor or that personal representative doesn't have that headache of chasing down people in order to be able to do that. And there are some ways that we can do that in the planning side, in the will. And then there are some ways that if, worst case scenario, it's not addressed, that we can handle it after somebody passes away when we're filing the return. But my thought is, let's go ahead and plan for that if we're able to plan for that. Later, she's going to be sending an email after this that has a survey just asking about future topics. That would also be another next step. If you want more detail about powers of attorneys, or our next session we can talk about trust or Medicaid planning, feel free to complete that survey. We welcome your feedback. I'd be happy to cover a topic in one of our virtual seminars. So that would be another next step that you can take. I also want to remind people that you're also welcome to request a free copy of the book that I contributed to, so that you can have that. That would also be a great next step. And we are going to give, in the email that sends out the survey, we are going to include a coupon in there. If you decide that you want to call, we do have a discount because you listened to me drone on for an hour about the powers of attorneys. And our thought is that you're already going to be a little bit educated. So we're happy to provide a discount for people who are willing to listen to this information and learn as we go along. So we also have our newsletter. This is a great summary. So everything I talked about here with powers of attorneys is in our first newsletter. So if you also either call or email Amy, she can get you a copy of the newsletter that has a summary of these powers of attorneys and why we recommend what we recommend. We're going to be doing a newsletter quarterly. So if you'd like to subscribe to, shoot Amy an email or call her, and she'd be happy to do that as well. We're going to cover topics like this in the newsletter. And again, we're going to try to do this monthly, so you're always welcome to email Amy with topics or to register. We'd be happy to email you a link every time we're doing it. We're going to be emailing you a link to the survey for the feedback, and we really do appreciate that. Okay, so any questions that we have, and a couple that I had that people had brought up to me prior, so I'm happy to talk about that quickly if we don't have any in the chat, which I don't see any so far. I think I've been answering them as they come in. So one question that I get is, what's the difference between a post and a living will? A post is Pennsylvania ongoing life-sustaining treatment. It's usually something you get through your doctor, and it's usually on heavier material like cardstock, and it's usually bright yellow, bright pink, and it's something that the doctor's office or the hospital is giving you. And the question is, what's the difference between that and a living will? So the difference is that a post is a physician's order. It goes onto your chart. So if somebody sees that physician's order, they will not resuscitate you, is basically what that is. What I tell people is posts are great if you have a diagnosis and you want to go ahead and put that as part of your medical chart. But most people that I deal with that do not have a diagnosis or do not have a terminal condition are not going to want a post. They're going to want a living will, because the living will is saying, I don't necessarily have a diagnosis, but I'm just saying in the future, if I would get one, these are the end of life decisions I want. It's not a physician's order. So it gives your agent, the person you're appointing, the flexibility to be able to consent to certain treatment, but not other treatments according to what they think you would want in that circumstance. So that's the difference between a post and a living will. My recommendation is that everybody needs a living will. Not everyone needs a post. A post comes into play if you have a diagnosis and you know for sure this is exactly what you want. Another question I get is, how do you deal with agents and appointing them? Can you appoint multiple agents? So in my example of me being the favorite child and being appointed, that's really not true. I have really great sisters, so I'm not the favorite child. So let's say that my parents wanted to name two of us and they wanted to say Sam and Jess or Sam and Amanda. My parents could say they have to work together, meaning that we both have to be in agreement before a decision could be made, or they could say either one of them. Because that way, my sister who lives in Maryland, she may say, well, you're closer. If you're going to be going to the hospital, you just sign whatever you need as the agent. So you can say they either have to serve together or either one of them can act. Okay. The other thing is that I do have, like I said, I have three sisters. So one of my sisters, her life, she is dealing with a lot and she has a child with special needs, and we want to offer support and provide that support for her. So my parents might say, you know what, she's really busy and we don't want to burden her with those decisions, but we want her to be able to access information. So if she's out in Pittsburgh and she wants to call the doctor and ask questions if somebody's in the hospital, we're going to give her a HIPAA release. We're going to allow her to call in. But if we have a life or death decision, then we aren't going to put her on the hook responsibility wise to be the person who has to be gotten a hold of to make that decision. So you can name somebody as the agent and they can also have a HIPAA release, or you can name somebody as an agent and you can give all your children a HIPAA release, meaning they can access the information, but you can name a specific child to actually make the decision. Next question is, what if agents disagree? And that would depend on what situation we're dealing with. If it's healthcare, then usually there's going to be a social worker at the hospital that gets involved to try to mediate a family decision. If it's financial, it goes to the court system and it will go before a judge, and a judge will have to determine what decision is best. So if you are going to name agents jointly, make sure that these agents can work together or that they'll be able to find some sort of resolution, or your parents or my parents could name all four of us and say a majority rules. And then it's, if somebody disagrees, that's not an issue. It just is the majority of, the people that you've appointed have to be in agreement. Okay, do I have any other questions? I know that I went through the ones that I had prior. I don't see any coming in here. I'll give it just a couple of seconds. My email address is Wolfe, my last name, WOLFE at SKW, and that's SK as in kite, W, lawoffice.com. You're welcome to email me with any questions or concerns that you will have about this or any other topic. And like I said, Amy will be following up with an email that has a link to a survey. It's just asking you to give feedback on what was helpful, what wasn't, so we can learn from it in the future. It will have the certificate on there. And then please feel free to reach out if you want to register for future seminars, or if you want to subscribe to the newsletter. We'd be happy to get you a copy of that as well, along with the book if you'd like that. So thank you everybody so much for being on the call today. I really, really appreciate it. We loved having you, and we're here if you need us. So thank you so much. You guys take care, okay? I'm going to actually end the meeting here. So you guys are welcome to exit as you need to do that. So thank you, everybody. I'm going to hang out here just in case I have any other questions, okay?
That post's been recorded.
Yes, if anybody's on here, it is being recorded. So if you'd like that as well, I can also get you a copy of that. And eventually we'll have access on our website for that. That is under construction. So hopefully we'll have that soon.